Welcome to this week's episode of Lawyers with Attitude. I'm Judy Ramjeet.
I'm Julian Young.
We are
The Lawyers with Attitude.
This week we're going to be interviewing James Lockyer. He's Canada's most famous lawyer, and he'll be talking about the high-profile appeal cases that he's dealt with in his long and distinguished career.
And of course you do know, Judy, what happens to an old lawyer?
I don't know, Julie.
He loses his appeal. That's ruined it. That's got you. You weren't expecting that. You have to keep going. That's the whole point of live TV.
So, Julian.
Yes.
James is going to be talking a little bit about the criminal appeal system in Canada, but I'd like you to inform our viewers about the criminal appeal system in this country.
Two sets of different types of appeal, which can be split up appropriately. You can appeal from the lower court, the Magistrates' Court, to the Crown Court, either against sentence or conviction. You can appeal from the Crown Court to the Court of Appeal against conviction or sentence if you get permission from a single judge in the High Court. And if those appeals aren't successful, those are the Crown Court to the Court of Appeal, you can go to an organisation called the Criminal Cases Review Commission. They'll look into the case and they can send the case on by way of review to the Court of Appeal. So there's more than one way to skin a cat.
And Julian, what are your views of the criminal cases review system?
Our system, I think, is probably as good as it can be because, of course, it's an outside organisation that looks at the submissions made on behalf of an appellant or an applicant, as they're called, and it's pretty good. They're fairly good at working out what is right and what is wrong, what is relevant and what's irrelevant. There have been challenges, one of them in the relatively recent past, but the system effectively works. But sadly, of course, in the middle of a recession, it's an expensive system.
Not every country that has a structured criminal appeal system has another tier, such as the Criminal Cases Review Commission. And I think that lawyers that we have spoken to in Hong Kong, and certainly James, when you spoke to him, indicated that such a further tier would be beneficial in their country's legal system.
Yes, because by and large in other countries you appeal to the Ministry of Justice, normally the same people who prosecuted the case, and therefore obviously you want to have an outsider, a completely independent organisation outside the court system having a look at the case, deciding whether there is in fact something which the judge or defence or prosecuting lawyers may have missed. So it's a pretty good system all in all, really, a pretty good system.
There have been some very severe cuts that have been imposed in the United Kingdom in relation to legal aid. We'll discuss this later on in the show. First of all, we'll turn to the interview of James Lockyer, whom Julian interviewed on an earlier occasion.
Today, I'm interviewing James Lockyer, a solicitor from Lockyer Campbell Posner, in Canada, who is the leading light when dealing with the question of appeals against conviction or sentence in the Republic of Canada. James, describe yourself, sell yourself to Lawyers with Attitude.
Well, first of all, Canada's not a republic.
Oh, all right, it's not a republic now, I've got that one. It's not a kingdom though, is it? It's a country, it's an independent country.
It's a country, yes.
Member of the Commonwealth.
But anyway, that really doesn't matter too much. Republic, country, whatever it may be, like everywhere else, we have plenty of wrongful convictions, and like everywhere else, we're not very good at exposing them. The system doesn't like to give up its convicted. So it's a real struggle to set aside the wrongful convictions, but we've had some success.
I congratulate you. Is that funded by legal aid or its equivalent, or is it privately funded?
Well, no. We have an organisation that actually I was one of three people. We founded it in 1993. It's called the Association in Defence of the Wrongly Convicted, AIDWYC for short, AIDWYC. And we take take applications, and then when we feel we can take on a case, we try and look for funding where we can. Sometimes it'll be legal aid. Very occasionally the individual will have funds, but that's pretty unusual. And sometimes we find other routes that we can get funded by. Sometimes we're not funded at all. Every case is different, really. And we take on the cases across Canada, and I think we've been fairly successful. We've been behind quashing perhaps 25 wrongful convictions now in some way or another.
Quite remarkable. Do you have the assistance of interns or members of staff, or is it innocence projects at universities and colleges? How is the legwork undertaken?
Usually by the lawyers themselves, private lawyers. There are some innocence projects in Canada, but they're more academic and disciplinary than they are practical. They do take on cases, but to date have not had a case of their own that they've successfully set aside. There was one case of ours that we did with the Osgoode Hall Innocence Project in Toronto a few years ago that ultimately we at ABWIC were successful in winning in the appeal courts. That was a chap who had spent 32 years in prison for a murder he didn't commit.
That's terrible, and one feels, of course, that poor man's life is effectively ruined, although he would end his days, obviously, as an unconvicted person.
Yeah, his name's Romeo Filion. It was a false confession case. Had an extraordinary quirk to it because when he was originally convicted, which would have been in, let me get it right, 1972, he tried to lead polygraph evidence at his trial to prove that he had lied when he confessed, and it was ruled by the trial judge to be inadmissible, and his conviction was upheld by the Supreme Court of Canada 2 years later, who held that polygraph evidence is not admissible in a criminal court. And then finally in 2003 we got him released on bail, and we won his case eventually in 2011. So it was a long haul, a long slog, his case.
Indeed. In England we have something called the Criminal Cases Review Commission. You know that if you're not successful, then you have to go through a public body who themselves will look into the case, aided by the submissions made by the lawyers on behalf of the person, if the lawyers are instructed.
We don't have that. I very much like the CCRC system, but we don't have it. We have the old Home Secretary application process that you had in England before the CCRC was created. With us, it's called it's a Minister of Justice application. But it's the same thing as the old Home Secretary process. Very unsatisfactory. At the moment, particularly, we have a very right-wing government in power, certainly to the right of your government, even your government in the UK at the moment. And so applications for ministerial review are fairly hopeless causes when you're making your application to law and order people.
Well, that's a shame, but of course, if you do find grounds, presumably you put them before the Minister of Justice, and the Ministry of Justice can't ignore you.
Well, he can. It's very hard to challenge his decisions, just as it was in England to challenge a Home Secretary decision. And in fact, to date, there's never been a successful challenge of a minister's decision in the decades that the powers existed. Oddly enough, I actually have one pending in about 3 or 4 weeks. It will be the first one I've ever done where I am challenging a minister's decision in the courts, and maybe I'll be the first first successful one. We'll see.
Well, as you know, we have something called the Wednesbury rule. That is, a decision is so unreasonable that no reasonable public body could have made that decision. In other words, I'll have a guess. You have an appeal in which you are able to show that DNA shows that the person convicted could not be guilty. If your Justice Minister refuses permission to appeal, you would say that's so unreasonable, the court at least has got to look at it because of the strength of that evidence. Do you have such a system, or am I sort of misusing the English system?
I think in a case like that, it's pretty unlikely the minister is going to turn you down. But yes, you could review an absurd decision. Yes, but of course, very often in these cases, there's always a power when you bring forward fresh evidence. There are so many ways they can dismiss it. They can choose to disbelieve it. They can choose to decide it wouldn't have had a whole lot of effect if it had been there at trial. They can decide that it probably wouldn't have been admissible at trial. Or they can say that, this could have been found by counsel at the original trial, so we're not going to admit it now because counsel didn't show the proper diligence at trial in introducing this evidence. There's so many ways they can wangle their way around around these applications, and the system fights very hard to protect itself. The system, and I suppose I shouldn't be surprised, but the system thinks that the exposure of a wrongful conviction is very bad for it. And really, it's very good for it. It should be a way of the system saying we really do work because we're ready to acknowledge our mistakes. But that's kind of wishful thinking that they'll ever think that way. They don't. And Crown attorneys, prosecutors, is what I mean by that, are forever saying publicly and to me and others that the last thing they'd like to be involved in is convicting an innocent person. And I think that would be better said if should really be translated into a Crown saying the last thing I'd ever want is to be discovered to have convicted an innocent person. Maybe a bit cynical on my part, but I think it's probably reality.
With your experience, which obviously is far greater than mine, aren't you glad that you're not south of the border where the death penalty exists?
Oh God, yes. I've actually been involved in cases south of the border, and I know the New York Innocence Project very well. I'm quite close to the Innocence Project people out of the original Cardozo Law School in New York, and I'm also close to an organization called Centurion Ministries, which I don't know if you've heard of it. It's in Princeton, New Jersey,
Right.
run by a chap called Reverend Jim McCloskey, a fabulous, beautiful man, one of my favorite people in the world. And Jim founded Centurion. He was a chaplain in a prison in New Jersey back in, I guess we'd be talking in the early 80s, late 70s. And he administered to a guy, a Mexican, who insisted on his innocence. And Jim managed to establish that he was, and then set up Centurion Ministries, and has been running it ever since. He's got more than 50 exonerations now to his name or to his organization's name. And he's not a lawyer. He's a non-legal organization. And he's got people off death row. And he and I have worked closely on several cases, both in the US, me with him, and in Canada, him with me. So if you ever want to follow up with the US, call Centurion Ministries and talk to Jim McCloskey. Beautiful man.
I certainly will consider that. Thank you very much.
Yeah. I got a Criminal Justice Award here several years ago from the Criminal Defense Lawyers Association, and I had to find someone to introduce me for the award, and I had old Jim come up from Princeton, New Jersey, because he's my favorite man.
Oh, that's lovely. It's absolutely delightful. Well, I'm glad to hear that there are lawyers prepared to stick their necks out and to work hard on behalf of people who may be innocent. I'm sure you get the same as I get, a vast number of people who claim to be innocent. When you look at it, the evidence really is stacked against them conclusively, or as conclusively as possible.
That happens. The cynic says everyone always says that they're innocent, and I don't actually buy that. That's not my experience. Most people who have committed a crime after they've been convicted of it will admit it. Because in many ways it can be in their interest to do that anyway. Better parole,
Yes.
more likely, and that kind of thing, if you're prepared to acknowledge committing the crime you've been convicted of. But certainly some of the cases that have come to me, I've had a cast a jaundiced eye over them and decided I can't help. A couple of them I've effectively discovered evidence that you might say prove guilt. But I would say they're actually a fairly small percentage of the cases that I actually spend more than half an hour on. I tend to find once I get my teeth into a case, it's usually because I've sensed from the beginning there's something wrong with it. Because these cases, wrongful convictions are not that hard to spot. You know, they usually involve evidence of a kind that is notoriously a part of a wrongful conviction. Eyewitness identification evidence, the use of jailhouse informants or jailhouse snitches, as they call them in the US, the use of junk forensic science, like hair microscopy comparison, that kind of stuff. The pathology is a very common cause of wrongful convictions, bad pathology, those kinds of things. And also cases that are dependent on what I call phony circumstantial evidence. That's another kind of case you run into quite a lot in terms of wrongful convictions, where the authorities stretch evidence to supposedly lead to circumstantial conclusions that they really don't. Like, you know, when I asked him if the police officer saying, when I arrested him, he looked down as if he was guilty, you know, that kind of shit.
That's rubbish, which you can frequently cross-examine out of a police officer.
Well, yeah, you can, but you know, you have that's a very simplistic example.
Yes.
You can get more complex examples where I have one wrongful conviction, for example, where part of their evidence against the next door neighbor, who was accused of a rape murder of a 9-year-old girl, was that he had gone out and helped in the community to search for her body when she disappeared. And when her body was found, he hadn't gone to her funeral. And those were two items of evidence that were used to convict him, as if they somehow were circumstantial evidence that tended to show his guilt, which of course they didn't.
Exactly.
And ultimately DNA cleared him. But you know, it's very satisfying work. I mean, one of the most satisfying things is that there's been a couple of cases that we've been involved in where we haven't just proved that someone was wrongly convicted of a crime he or she didn't commit, but in the process we actually proved who did it too. We have a couple of people behind bars doing life sentences for crimes they committed as a result of the work we did for the people wrongly convicted of those very crimes being in prison for.
Is compensation available for someone who's been wrongly convicted?
Not necessarily. Many of our people have been wrongly convicted. It's usually a major struggle. The state likes to take the position that we haven't proved someone was wrongly convicted. We've only proved that there was a reasonable doubt, for example. So they sort of take the position that the civil burden of proof, we won't establish that they were wrongly convicted, and so they resist a civil claim, a civil suit for compensation. So we have a problem there. That's happened in several cases here.
Maybe you want to borrow from the Home Office here the miscarriages of justice compensation scheme. We have one. It's a statutory scheme, and it's an application is made for compensation. It's on the basis that the person who has been wrongly convicted was in fact totally innocent.
not an obscure point of law, but if actually it's been possible to show they could not be guilty, and there are payments made.
In many of the R cases, you can't do that. Potential forensic evidence has been destroyed, perhaps in many cases, doesn't exist anymore, so you can't prove innocence, you can't prove who actually committed the crime. So many of our cases, the skeptic would say, well, maybe he or she did commit the crime, even though it's quite apparent that he or she didn't. And that's a problem. That's a problem south of the border too. And south of the border, very often to set aside a wrongful conviction, you have got to prove innocence. At least we don't have to do that to set aside the conviction. But you do, practically speaking, you do often have to show that to get compensation after you've set aside a wrongful conviction.
Well, James, thank you very much for giving up your time to chat to us, to chat to me today. Congratulations on the award. You must be very proud of it. And to get your friend to come from Princeton is an achievement in itself. Working and fighting for justice is something we all have to try and do if we possibly can. It's, as you said, it's a long, hard struggle when you're fighting against the resources of the state and there's only you and perhaps a member of the bar or two members of the bar against the full weight of the state. And
It's very fulfilling when you're successful.
And sometimes the client says thank you, and that's what makes it worthwhile.
They always do.
That's lovely.
Yeah.
Well, James, have a very pleasant day today. Thank you very much indeed for letting me speak to you and for giving up your time. And I have no doubt we'll speak again, probably on an informal chat basis rather than formally.
Fantastic.
Have a lovely day.
Passing now to those legal aid issues which you raised. It will become very complicated because the government considers that legal aid is not that important in the great scheme of things, and they can save some money. Quite what they'll spend it on is another matter altogether, probably on some expenses somewhere, subsidised food, subsidised one of these, I think 18 different bars they've got in the House of Commons.
No wonder you're known as the lawyer of attitude.
I've got an attitude, and if I'm afraid to say if you're going to cut legal aid, then you haven't got the money obviously to spend on all sorts of other things. But yesterday, the 1st of April, and it wasn't a joke, the Legal Aid Authority was set up. At the same time, a lot of different types of cases came out of scope, that is, were no longer covered by legal aid. Certain family matters, in an attempt presumably to get people to mediate and not go to court. Issues about some contact with children. Cases with domestic violence are included in legal aid. Most personal injury cases have now come out of legal aid scope. Housing cases are coming out of legal aid scope. And this is all really a step backwards. In 1948, 1949, when the welfare state was set up, it was accepted there will be health, dental health, and personal health. And also part of that scheme was going to be a legal aid scheme that those who could not afford it would have access to justice. I'm afraid the coalition government has taken a step backwards. Access to justice has been cut. And I think eventually that will come to rebound badly on the government and on the civil servants who advised in support of these ideas.
Turning on to a lighter topic, it's that time again. Yes, it's Joke of the Week.
In fact, I'm not really going to tell a joke.
Oh, thank goodness.
But you see, it was very recently, the 1st of April, the date when traditionally, of course, say in France you have Poisson d'Avril, which is putting little signs on people's back like kick me or kiss me or something like that. Wish somebody would kiss me. But
Don't even look at me, Julian.
somebody as beautiful as you, obviously you know what to seek from you. But on BBC in about 1957, and I remember this because I was a very young child and my parents had a television set for a while, Richard Dimbleby, who was the anchor man, rather like Jeremy Paxman is nowadays, produced a short clip about the spaghetti harvest in Switzerland. Look it up on the internet. It is hilariously funny, partly because of the stilted language and partly because in those days the BBC was the only television station and you accepted what it said, and especially somebody with the gravitas of Richard Dimbleby. It was unbelievable. People genuinely believed that pasta grew on trees. You went to a spaghetti harvest. And indeed, I think one of the suggestions made by the BBC to get the right type of tomatoes was to plant a sprig of tomatoes in a can and see whether it grew or not. It fooled a lot of people in the relatively unsophisticated 1957. The other thing which has happened was in 1977 or 1979, The Guardian produced a small pullout about an island called Sans Serif, which was in fact shaped rather like a semicolon. It was two islands which are loosely linked. In fact, the whole thing was a spoof. All the terms they used the term of Bodoni, which was one of the tribes, and flongs, and these were all printing terms. People weren't easily fooled, but it led to an annual attempt, especially by The Guardian, but by advertisers as well, to put a spoof in. So we saw this year, I think BMW, who do it quite frequently, put one into the Sunday Times all about BMW prams, especially for the forthcoming royal baby. And it was powered by nappies, and I can't remember what nappies stood for, but it was funny, and it's worth looking up on the internet if you can. So it's not real jokes, but it's a chance perhaps to go and look at the best of the spoofs for the 1st of April over the last few years. Look and enjoy. Rather like you should look and enjoy every episode of
Lawyers with Attitude. If you'd like to comment about anything that you've heard on this week's show, then please tweet Julian, who is the Lawyer with Attitude.
Got that little funny and sign, and then capital T for the, and then LWA. So it's and Lawyer with LWA, Lawyer with Attitude. And you'll find me, or perhaps you'll want to hide from me, I don't know.
Or alternatively, please email either myself, Judy Ramjeet, at jylaw.co.uk, or
Julian Young at jylaw.co.uk. Look me up on the internet, you'll find me. There's plenty of quotes there for you to find my email address, julianyoung at jylaw.co.uk. I'll put my teeth back in, and well, that's the end of this week's episode of
Lawyers with Attitude.